Welcome to Estate Planning Beyond the Binder.
Welcome back to Estate Planning Beyond the Binder with Brian Chu, managing partner at OC Wills and Trusts and a leading estate planning attorney serving Orange County families for over 25 years. My name is Kevin Rosenquist, and in this episode, we're talking about when and why your estate plan might need an update, from new grandchildren, remarriages, property changes. Brian's going to walk us through the life events that should trigger a legal review and what can go wrong if you wait too long. Brian, welcome back. It's good to see you.
All right. Thank you, Kevin. Thank you for having me on today.
Absolutely. So we're talking about changes to an estate plan here. So in general, what are the main life changes that should trigger a review of your estate plan?
So let's assuming you have a revocable living trust, typically, and obviously you can change the trust anytime you want. And as I tell most of my clients, the primary reason you're changing your trust is because a relationship has changed. It's gotten better. It's gotten worse. Rarely is it, since 2012, we really haven't had any legal change. In other words, there haven't been any changes in the law that have triggered, triggered us to tell our clients, hey, you may need to think about updating your trust because this has changed. Most likely it's going to be, and usually it's not an asset change necessarily. Okay. We'll talk about that later, but as long as your assets are going by percentage, whether it be equal or otherwise to your heirs, you generally aren't having to update the trust because you've changed assets. Okay. Now, if things aren't going by percentage and there was some specific assets, you might want to do it because assets have changed. But the more likely scenario is because a relationship has changed. It's gotten better. It's gotten worse. In my case, my kids are young. They're 15 and 16 right now, or 15 and 17 right now. And if something, and they would, and thus they're not going to be in charge of our trust, obviously, or even if they were 18, they may not be in charge of our trust. But, a decade from now, when my kids are more mature and I can trust them, I might change my trust and other documents to make them my primary trustees, power of attorneys, healthcare agents, and so on. So that's for most of my clients, that's typically the number one reason why they're updating the trust is because their kids are growing up, and now it's time to put them beyond just being a beneficiary to put them in charge. And so that's an example of a relationship getting better. I can trust them. Okay. Unfortunately, it can work the other way around, which is with my existing trustees or agents. That relationship changes in the sense, I don't trust them as much, or I don't, someone gets, something happens, and my relationship with that person is not as good, and I may need to take them off. Okay, those would be the two most common. And then the other is just, it depends on how the trust is written or how comprehensive it is. If somebody dies, you don't have to take that person off. Presumably, that trust addresses the issue. Okay, that person's not alive, it goes here. That person's not alive, the next person's up. Now, obviously, if you start running out of people, then we may, if we're down to one person, I always like to have at least two backups for everything. If we're down to one person for any particular, whether it be a beneficiary or a potential person in charge, I'm going to want to amend the trust to add more people. So that's an example. Again, if your relationship getting worse, they're not available. But again, as long as you have at least two or three, backup plans still, viable at that point, then you don't necessarily have to amend the trust because somebody died. But if a relationship changed, you definitely want to update the trust. And so that's an example, unfortunately, where the relationship's gotten worse.
So obviously, divorce, remarrying, having more kids, those are probably the biggest ones that people would really want to go and make changes to it.
So as far as having more kids, generally most trusts, and again, at least the ones we write, would accommodate more kids. They would accommodate grandkids even potentially in terms of being backup beneficiaries, because the way we write it is one share. If something happens to you, and again, just assume you're treating everybody equally, it's going to be one share for each of them living children. So one kid, one share, 5 kids, 5 shares. Okay, and so we write the trust up so you don't have to amend the trust because you have more kids or even grandkids. Example, even though my kids obviously don't have kids, the trust writes that if any of my children predecease me and have their own kids, their share will go to their kids equally. And so that's already addressed in the document. Now, obviously, divorce, that's a completely different story. So if you have a joint trust, you get divorced, you will need to amend. You will not need to amend your trust. You're going to need to do something different, presumably. You're going to need to get both sides probably should get their own trust at that point, and then they'll obviously individually decide how they want to proceed for them. And then the key there is because in a joint trust, you're trusting your spouse
Right.
And unfortunately, that may no longer be the case.
Yeah.
And then,
Yeah.
especially for those people, well, that's the key issue is obviously, as soon as your trust in somebody goes away, you've got to change it. That's in your documents that's going to be in charge. You need to change your documents at that point.
Is it risky to let your estate plan collect dust once it's done? Is it like, what are the concerns, the biggest concerns or the biggest issues you've seen with people who aren't considering, who aren't reviewing it?
So, one thing we try to do as a firm, because we're one of the bigger estate planning firms in Orange County, we have the ability to stay in touch with our clients. And our job is to remind you every now and then that you do have a trust, whether it be a phone call or email, whatever it is, we do what we can to remind you have a trust. Because yes, it's not necessary. And our job is just to remind you to think about it. Has anything changed? Okay. If nothing's changed, yeah, you're probably okay. Okay. If, again, more kids, it's already accommodated. But again, if a relationship has changed, that's when you would need to, you would want to consider updating the trust. And, or if you had any specific provisions regarding an asset and something's changed with that asset. In other words, sometimes I have clients, especially like they might be trying to take care of their parents. They might say, I want this to go to my parents. And then over the course of time, that house gets sold. And well, if they sell that house, that parents don't get that house. And maybe they need to replace it with another house. So then, yes,
Right.
they would need to amend the trust because the trust specifically specifies something, not so much that it isn't there, because if it's not there or the parents pass, it doesn't happen. But if they want to keep the provision going, but need to replace that asset, then they would need to update the trust to reflect the new asset they want to go to that parent. So that would be a typical situation. The other situation is you're generally not updating the trust for assets. In other words, your trust is like a bucket. Whatever's in the bucket is your heirs are typically going to split up. Okay, so again, as long as it's by percentage, not a problem. But the key is, and this is where we play a big role, is it's not that your trust has a problem, it's the fact that your trust is not properly funded. Okay,
Yeah.
funding the trust is critical. You need a trust to either be the owner of assets or be the designated beneficiary of the assets at the institutional level, the bank, the 401k, the life insurance company. As long as the trust is the owner or beneficiary of all your assets, not a problem. But that is the biggest thing as we come in. I just had a client come in yesterday. They own 4 properties, 3 of them in the trust, the 4th isn't. Good news, we can fix that. But had something happened to that client before they came to us, that property, the 3 properties would have avoided probate, which is one of the primary goals of having the trust. But the 4th property would have gone to court. And in this case, it's even worse because in this case, the client in California, if your property goes to court, a probate, and in this case, he's using what we call Medi-Cal, which is it's equivalent of Medicaid in other states. It's a government provided healthcare. The state would have come back and wanted their money back for all the benefits they gave to him because the case went to probate. So even though he had a trust, that's why, I always tell my clients, and that's why it's beyond the binder, estate planning beyond the binder, is because having the trust in of itself is not enough. You need to have the trust and it needs to be properly funded. We take care of some of it for our clients, but again, things will change over the course of people's lives. We won't know those things have changed. Only the client knows those things have changed. And our job is, what we feel an obligation to do with our clients is to remind you, hey, if something's changed, you may need to do something. And then we're there to support them to hopefully get that done. But again, we can only do so much because we won't know something's changed in terms of assets, and that, we won't know whether something is or is not the trust, because the trust itself does not put things into it. You have to do something at the institutional level, the recorder, the county recorder for properties, the bank, the life insurance company, the 401k company. Something has to be filled out on their end to make sure the trust is affiliated with that account. Because anything short of that, it's the bank doesn't care.
Right.
They don't care whether the trust is involved or not, because that's none of their business. And you can say all you want, because people, and that's why we don't even list assets being in a trust, because people think, oh, I list the asset being in the trust. It's in the trust. It's not. The bank doesn't care that it's listed in the trust. The bank just cares, did you file paperwork with them to put the asset in the trust?
Have you found that outdated documents, outdated trusts can actually cause more problems?
I would say at this point, so a trust by itself doesn't have an expiration date. It's valid for the rest of your life. I would say the biggest number one reason why we're updating somebody's trust for a legal reason is because in 2012, the government changed the estate tax laws pretty significantly. And one of the biggest things they did is they made it easier for people to have a revocable trust to have assets pass between the spouses. Before, if you had a trust that was done before 2012, it's a very good chance that trust is what we call an AB trust. Okay, an AB trust says that when one spouse passes away, The surviving spouse is to split up the assets into two trusts, an A and a B. The A is the survivor's trust, their share of the trust. The B is the decedent's trust, the person who died below ground. And that is a pretty significant administrative issue because now you have to value all the assets. You have to allocate them between the two trusts. And while you have complete control and access over the A trust, you have complete control and access over the B, but you don't have quite complete control of the B. There's some restrictions on there, and usually this is not put in there for control issues. This is put in there for estate tax issues that can be overcome much easier today. So they changed the law in 2012. A, most people don't have an estate tax issue, so the reason to do an AB, if that's the reason to do it, most of us, there's no reason to do it. B, that law actually might be potential if you actually did it, the AB trust, and or forced to do it now. It's actually the way those AB trusts are written. They're actually potentially harmful for the kids for tax wise, because originally they were designed to protect the kids and have the family pay less in taxes.
Sure.
Now an AB trust provision, if it's actually enacted, if it's actually still in there, and written not up to the current standards, then the kids actually might end up paying a lot more in taxes that they otherwise wouldn't have had to pay had they done nothing. They would have paid less in taxes.
Right.
But so that's the most common thing we're amending out of people's trusts now is, again, assuming everything else, there's no control issues. In other words, surviving spouse is not concerned about what the spouse who passes away first is not concerned what happens with what the surviving spouse will do with the money. Assuming that's not the issue, usually we just say simple, survivor gets it all, nothing happens, you don't need to amend the trust. Unfortunately, at that point, one of you alive, you're in charge, and it's your money. And so it's simple, but also from a tax perspective, when the kids inherit the money one day, they'll have gotten the best possible tax benefits from the trust or from the fact that you passed away if it's set up as without the AB provision.
When someone decides, okay, I want to update my estate plan, I need to update my estate plan, what's the process? Is it kind of like starting over, or is it really just an amendment? Is it pretty simple? Can you kind of walk us through what happens?
So it depends on who you go back to have this done. Most attorneys, if it's my client, I did the trust for them. I will go in and amend specific especially if it's fairly straightforward. They're changing the trustees, they're changing the beneficiaries, and it hasn't been like a decade or so. I will just amend specific paragraphs in the trust. Now, if it's been longer than a decade, maybe I might recommend doing what's called a restated amendment, which just updates the entire document with my document, with a new document. It doesn't change the name of the trust or the date of the trust. That remains the same. But it does refresh all the language just to reflect again, it's more subtle changes in the law. It's not any major change in the law necessarily. It's just, dealing with issues that didn't exist 10 years ago, cryptocurrency, things like that are addressed in this trust. And again, I don't have any cryptocurrencies, in which case it wouldn't matter. But we might do a restated amendment, but normally we would update individual paragraphs. Now, and so in that sense, we're not starting over. Although if you're updating agents, we are going to do new wills, new power attorneys, maybe new healthcare directives, again, depending on those agents. But the trust itself are typically amending, okay? And in this case, amending specific paragraphs. Now, if you're a new client to us, you may have a trust done by somebody else. And I think this is generally the policy of most attorneys is when they take on a client who did a trust done by somebody else, their policy is to do the restated amendment. Their policy is not to go in and fix individual parts of that trust, because from the attorney's perspective, once we get into that document, we at some level assume some liability for that document. And I don't want to assume as an attorney, we're always CYA. I don't want to assume any liability for documents I didn't do, because I don't want to read them. It's not worth our effort to read them. I'm going to do a restated amendment where it's going to be, I don't care what the current document says. My document's going to override that document. So I don't have to worry about what the old document says. So in that sense, I am starting over with my client, with a new client, I am starting over with them with a restated amendment. Now, the good news is if they have funded the trust, they don't have to change any of that. That can remain the same. That's why we're keeping the same name and date. But now they're going to get a brand new set of documents, essentially. So I'm going to ask them the same questions I would ask them if they didn't have a trust. I'm going to ask them the same exact questions, go through the same proceedings as if they didn't have a trust, because I always tell people, I don't care what the current document says. I care what you want it to say.
Right. That's a good point. It's a good way to put it, for sure. Now, if obviously I know it's one of those things, a lot of people, they know they need to do an estate plan. They drag their feet. It takes forever. It's overwhelming. It's, I'll do it later, blah, blah, blah. Is it even tougher for you to keep clients, help clients update their plans and keep them current?
No, I wouldn't say, I don't know if it's harder. I mean, the issue is, and this is the issue from a lot of states. The nature of our business is we're gaining clients faster than we're losing them. Okay. Our client pool of people that we serve just keeps getting bigger and bigger.
Right.
Okay. And that's true for pretty much all estate planning attorneys, because if 89% of our revenue comes from new clients. And so the hard part is if you're not working with a firm that's growing the size of their firm, whether it be the number of attorneys or the amount of staff, any individual attorney cannot keep up with their existing clientele. It's just simply impossible. Okay. That's why we need staff. That's why we need systems to make sure we do everything we can to stay in touch with our clients. Just to, again, remind them to have a trust. Check in with them occasionally. But because if you're relying on the attorney to do that, forget it. They do not have enough hours. And that's not a good use of their time. Okay. Right. Just making a random phone call, that's not a good use of their time. You want your team to be doing that, to be checking in with your clients. And just as importantly, though, on the other end is, and this is the biggest issue we find, and this is how we end up getting clients from other attorneys, is because 89% of our revenue comes from new clients. When a new client calls us or an existing client calls us, and I have to make a choice, who do you think that attorney, if they're small firm attorney, who do you think they get back to first?
Yeah, the new one.
New client.
Yeah.
Because they represent, those are the people that are going to walk away if they, you don't call them back, and they represent most of your revenue. You're going to be out of business pretty quick. Okay. The existing client, all right, you'll get back to them when you get back to them. But they don't represent that much revenue to you. You have no legal obligation to respond to them. And, again, if you have to make a choice, you got to work with the new clients because they represent your revenue. That's how you stay in business. And that's because a small firm attorney, they don't have a choice. They've got to work on the new clients. Right. We design our firm so we can do both. Okay. That's because we have separate teams. We have a separate team that works with new clients. We have a separate team that works with existing clients. And so at the same speed and responsiveness we have to new clients, because of the size of the firm, we can be responsive and as quickly to the existing clients. Because I always tell clients, it doesn't matter how good your attorney is. If you can't get a hold of them and they don't respond to you in a timely fashion, it doesn't matter how good they were. Can you get a hold of them, and can that staff do something? They're not just an answering service. Because again, answer service, voicemail, okay, someone's got to get back to you. You're hoping they get back to you. When you call my team, during normal office hours or even sometimes after hours, they're either going to answer your question because they're authorized to answer certain questions. B, get an answer to your question. If it's a fairly straightforward question, they go ask the attorney and respond to you. That way you get the answer quicker. Or C, if it is more complicated, set up an appointment with an attorney so they can answer those questions. And we don't, as a firm, at least our policy is not to charge our clients for that, because I never want my clients to be afraid to ask questions. Because if they don't ask questions, that means something needs to be attended to potentially, and now it's not being attended to. And I never want my clients to be, I never want my firm the reason why your plan's not effective, because that's a big thing for us. We want you to have an effective estate plan, both now and in the future. And your ability to interact with us is critical to that. Because, if again, we don't answer your question, maybe something needs to be done, it's not being done, now your plan's less effective. And, the other thing is, half the time, my clients do call us and they have a question. Half the time we say you were fine. You don't need to do anything. And at least you got to answer your question. And so, that's our goal, is that our clients are not left hanging. And that's why we call it estate planning beyond the binder, because it's not the binder. The binder is the start. You need it. You don't have the binder, you don't have a plan. But there's things that need to be done. And we feel a professional obligation to our clients, because again, we don't have a legal obligation to follow up with our clients. No, very few attorneys do. We have a professional obligation to check in with our clients, just to remind you have a estate plan, so it isn't gathering dust. It's not out of sight, out of mind too long. And again, if it's designed right, again, unless a relationship change, you probably don't need to update it, but you never know. And that's our goal as a firm, is to make sure your plan continues to be effective. And the best we can do is, the most we can do is be responsive, check in, follow up with you every now and then.
Mm-hmm. All right. Well, if it's been more than a few years since you created your estate plan, or if anything in your life has changed, it might be a sign to take a fresh look. Brian and the team at OC Wills and Trusts make it easy to review and update your plan so it still reflects your wishes, your family, and your future. Visit ocwillsandtrusts.com or call today to schedule a review. And be sure to leave us a review, subscribe to the channel. We very much appreciate it. Brian, it's great to see you again. Thanks so much for your time.
All right. Thank you, Kevin. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.